it's funny because if you would have asked me this 10 years ago, I would have said, you never see a person record their trust. In the last 10 or 15 years, I've probably seen, and by the way, I've probably looked at, I don't know the real number, I'm going to make up a number that I'm going to say is for sure low. I would have to say I have looked at least 3,000 to 5,000 properties that have a trust. It has to be that number. I've never counted, but it has to be at least that many. I believe I've seen about 5 to 10 times where they actually recorded the copy of the trust. It's very rare. And they may record a copy of the trust more often, but when it records, it's just out there in cyberspace. It's on the public record, but it's not discoverable because it's not posting to a property. So if grandma created a trust in 2008, and there's 1 million documents recorded in LA County, for instance, every single year, probably more than 1 million, but let's just say 1 million. So it's one of those million, and what year did she record it? Did she record it in 2008? Was it in 2012? It's impossible. It's like searching for a needle in a haystack to find a copy of a recorded trust, unless they somehow put some information that will allow it to be posted to that property.
So, moral to the story: don't lose the trust.
Don't lose the trust. Put that the recommendation is the homeowner should give it to whoever the successor trustee is, and if there's more than one successor trustee, maybe they should give it to those. I'm not giving any advice. I'm saying the recommendation from what we've seen on our transactions, the people that are able to do their transaction as a successor trustee are the ones that have a copy of it. And it's because the person who created the trust gave them a copy of the trust, or put it in a safe deposit box and let people know where that was, or something like, or kept it on their computer and someone has access to their computer.
Yeah, and just to chime in on that, I'd say that easily about half of the time that there is a trust, the person that is a successor trustee doesn't have a copy of it. I don't know why, but they don't. And we're, again, back to square one. If we can't find the trust, there is no trust.
Yeah, and just to share some of the things we've experienced on some of our transactions, hopefully the law firm still has a copy of the trust, and if the law firm did save a copy of the trust, you can find out, if you can discover who the attorney was, because it's not always known, but if you find out who the attorney was, then you can go back to that law firm and maybe they'll have a copy, but it makes it very challenging when people have to search for a copy of the trust.
Okay. I'm glad you brought up attorneys. Let's talk about that for a few minutes.
Sure.
So I know that the probate court encourages people to file on their own, in pro per. They give them guidance. They give them the documentation. It's still a process that is it's complicated enough for us, where we have trouble talking about it.
Yeah.
But for somebody who's considering doing it, but I don't want to spend the money on the legal fees, I get why they would do it, especially in light of the fact that there are so many reverse mortgages out there now that in the past, when somebody inherited a home, they inherited a home that is free and clear. Yeah. And in today's world, we're seeing that half of that equity, even more of that, could be now taken up by a reverse mortgage. So heirs are looking at that and they're saying, okay, well, how do we get the maximum inheritance we can? Well, let's do it ourselves. Mm-hmm. Let's avoid hiring an attorney. But there's got to be times where even if you can, you shouldn't. And I know you see this happen all the time. What examples can you give us that where somebody just should have gone straight to an attorney and got started with them as opposed to trying it on their own?
Okay, and I'm going to start with my consistent advice that I always give. People should get legal advice. If you're dealing with a legal matter, you should have legal advice, because there are twists and turns in the road that you may not know about. But you asked for an example. I'll give you an example. So some people believe that when you're doing trust administration, because you don't necessarily need a court order or anything to sell a property, that you don't need an attorney. So I had a client call me about 18 months after we sold a home. They sold the home. The real estate agent calls me and says, hey, remember that transaction we closed 18 months ago? Well, this is a trust, but you could have the same thing in a probate. The successor trustee just got a bill from the tax assessor saying X amount of thousands of dollars is owed for a property tax reassessment. And so I asked, I said, yeah, there's always going to be a property tax reassessment. It's a known fact. And didn't the attorney tell her that when they administered the trust? And the response was, well, there was no attorney because there's a trust. They didn't need an attorney. And my response was, well, that's why they needed an attorney. Because an attorney can foresee that, will know that there's going to be a property tax reassessment based on the change in ownership date, and would have let them know, withhold some money or keep some money aside to be able to pay the. So anyway, long story short is that successor trustee of that trust received a bill, and that bill comes in their name, and it attaches to any property they own. So now they have a tax bill. Can you imagine distributing, your parents' estate to however many siblings you have, and then 2 years later you got to call and go, hey Frank, remember that check I gave you from mom's estate? We need $3,000 of that back. That's not a fun phone call. It's not a fun situation to be in. So you asked for an example. That's an example. I would say that, and I could give 5,000 other examples. One, I'm dealing with someone personally right now that